Justice Breyer, Lady Bingham, so pleased you're here. My lords, ladies and gentlemen, I'm delighted to welcome you to this, the first substantial event of the Bingham Centre for the Rule of Law. And thank you so much to Hogan Lovells for their kind hospitality here this evening. Justice Breyer took degrees from Stanford University, then Oxford, where he was a Marshall Scholar, and then Harvard Law School, where he then taught for a number of years. And from 1980 to 1994, he was a judge and then chief judge on the US Court of Appeals of the First Circuit, after which he was nominated by President Clinton to the Supreme Court.
Thank you very much, Jeffrey, and thank you for hosting this, and thank you to the Bingham Center. And why did I write this book? And now it's pretty clear from talking to you and others that there is a question in Europe, just as there is in the United States, a big question. Why, if we have a court that has authority to set aside a rule of law, a statute, for example, passed by an elected parliament, elected, 9 judges in the Supreme Court, they're not elected. So why should these 9 have the authority to set it aside? That's the easier part. Why do people pay any attention to what they do? Now, that's what I want to talk about, but I'm writing not really for you, maybe for the law students, but I'm really writing for an American who is very busy and isn't a lawyer and isn't a judge, and this woman has in the supermarket, and maybe her husband's there with her, she hopes. And they're trying to feed the family, and they're busy, and they know the Supreme Court's something interesting, and maybe important to them, but why? Really, who cares? Why should they? I say, please, give me a little time, because I think you should. What? I think you should know. I think you should know what we do. Harry Blackman told me that when I took his job. People want to know, tell them. Tell them, because if they don't understand it, you won't get the support. And if you don't get the support, not for any one decision, but in general, there won't be a Supreme Court. Now, so that is a question that Hamilton didn't answer. I mean, this is a document they wrote. All right, it's a pretty good document. I mean, 18th century. It encapsulates the thought of the Enlightenment on the continent, and probably the Scottish Enlightenment here, and certainly Locke and everybody we know and we read about when we were undergraduates, and there we were, and I don't want to take an exam on them now. But they are right here in this document, all right? Frozen in time. Their ideals. Hamilton knew that. So did Madison. But he said, you know, if we don't have somebody who can enforce it, somebody who can set aside an action by legislature or president that is contrary to the document, well, let's hang it up in a museum. Let's put it in the National Gallery. Now, he wouldn't have put it in the National Gallery because that was in Britain, and they were much against Britain at that time. But you get the idea. Hang it up in a museum. We've got to give someone the power to enforce it. Who? The president? Well, if he's president, my God, he's powerful enough already. He'll become a tyrant. No, can't be the president. He can't have the power both to do it and set it aside. Congress. They're the ones that are elected. Perfect. Well, not quite. Why not quite? Well, they're very good experts, by the way, on popularity. I mean, if they weren't, they wouldn't be where they were. But many of the words in this document are designed to protect people who are not popular. Indeed, the least popular person in the United States has the same rights as the most. So, I mean, we really expect Congress, having done something very popular, but totally wrong, to say, okay, we'll set it aside? No, please. We'll give it to these 9 or 7 at that time, however many, these rather, he probably didn't know how many, obscure judges, sort of almost like bureaucrats, gray in color. No one knows their names, and they have neither the power of the purse nor the sword. Fabulous. They're weak. No purse, no sword. They're sort of a professional. They won't do too terrible a job. Give it to them. And then he never answered the question, because he didn't know the answer. And the question is Hotspur's question. Wait, they're weak. No purse, no sword. They're going to set aside laws, perhaps, and they did think they would set them aside, that were unpopular, to set those aside. Popular laws. Set aside when they're unpopular. 9 obscure people. No purse, no sword. I've said that already. And then what question do we get to? It's Hotspur's question, and that's the organizing theme of what I write. So half of this, and I think I'm going to give you 3 sentences, half of this is about this. It's saying it's not that there's nothing to be said in reply. It's not just case by case, whatever comes to your instinct. It's not everybody trying to do the good thing. There is a long tradition in law, a long tradition, which I think I go back to the 18th century, found in one of the historians, a good account of a late 1790 judge in Connecticut, Jesse Root, I think, who said American law, and there he's modeling himself after some of the great British judges, deliberately. He's saying it's a question of prudence and pragmatism. He says reason and utility. Those are the criteria by which we judge. And I can say I can look at the opinions in the past of judges I admired. Judges I admired. Cardozo, Brandeis, Holmes, Learned Hand. And I think they follow this. And I think if you look at their opinions, you will look and you will find such things as a tremendous emphasis upon purpose. A tremendous emphasis, human purposes, upon values, those values of the 18th century embodied in the document. You'll find an effort to be utilitarian or pragmatic. Then Justice Scalia will say, congratulations, you found our next 4 bumper stickers. And I'll say, no, but the idea is you look past into the past, and you look for values that don't change, and values are the same. The principles don't change. The human right values, etc., don't change. Circumstances change. George Washington didn't know the internet, and we have to apply freedom of expression to those changing circumstances. That's what we're trying to do. He said, well, you're getting a bit beyond the bumper sticker stage, but not much. And so now we have to have 150 pages discussing particular cases, discussing areas of the law, like statutory interpretation, administrative law, which I love and no one else does, federalism, or how you use, here you call it subsidiarity, stare decisis, higher courts dealing with lower courts, and how the court deals with the President of the United States in an area where his power is at the peak, for example, national security, in conflict with the need to maintain some value imposed, enforce human liberty provisions of the Constitution. And I have to show you, bit by bit, that that isn't a bumper sticker, that it has practical values, practical interpretations, and leads to practical results. So if you look at the effort in World War II to put 70,000 American citizens of Japanese origin in camps, why? Why? It didn't work. It didn't work. It was all power to the President. And if you look at the Guantanamo cases, where in fact, for internees, i.e. detained people, i.e. prisoners, not popular, bin Laden's chauffeur is not a popular person, against the President of the United States. And those 4 win each case, and the President loses it, and the President says, I don't agree with that, but I'll follow it. I mean, that's an advance. And why? And how? And it's in the details. Well, there we are. This was just an effort to entice you into looking at this book, because it is an effort which may be pertinent wherever there are judges and lawyers as to how to convince a group of people who are not that it actually is a difficult profession, where we don't just do whatever we want every day, where it isn't a question of subjective value, where we are guided by what's objective, and that there are approaches, relatively objective, that we can use in deciding these truly difficult matters of conflict, often where it's good against good. The proof of the pudding is in the eating. But this, of course, is what I've tried to do.